Welcome back to Arbitral Voices, videocast series presented by Young ITA. My name is Shay Lakhter, and today I am privileged to be joined by Stephen Drymer. Stephen is a partner and head of international arbitration in Woods in Montreal. He acts as counsel and arbitrator in domestic and international commercial arbitration, investment treaty disputes, and sports arbitration. Stephen, thank you very much for joining me today.
Shay, it's a great pleasure to be here.
You started your career in litigation, but
Yes.
now you mainly work in arbitration. Maybe you would like to tell us, how did you get to this field of work?
It was the purest serendipity, and I mean that because it wasn't only fortunate at the moment, it became a very fortunate and wonderful turn in my career. But it came about very simply. Yves Fortier, as he was becoming what at the time was called the king of international arbitration, came walking around the office one lunchtime looking for a warm body to assist him on a case. And I think I must have been the only one sitting there at lunchtime. Almost by chance, we started working together. And I started learning the profession of arbitration lawyer at that time. I think I was in my second year of practice, so a real baby.
And now you are an established arbitrator, but can you tell us, how did you get your first appointment?
That's a question I can answer quite directly, at least insofar as investment treaty arbitration goes, because sometime after my first appointment in a case called Burlington and Ecuador, I didn't ask, I thanked Jan Paulsen for the opportunity. And he told me exactly why and how I was selected in his inimitable and very bluff and friendly fashion. He told me, Stephen, you have to be good and you have to be lucky. He told me, we knew you were good and you got lucky because the first person we approached had a conflict.
And now you still act as both counsel and arbitrator.
Yes.
What is the side that you prefer in both practices?
I see. You know what? I think I have to say that in both, as counsel and as arbitrator, the element that I like the most, and it's probably true for most advocates at least, is the hearing. As counsel, it's examining witnesses and especially arguing one's case. And as arbitrator, whether as co-arbitrator and perhaps even more so as chair or presiding arbitrator, it's being involved in that process, in hearing witnesses and questioning witnesses, and of course in discussing with counsel as they argue their case.
And so now you already had a long career. And do you have a moment of which you are especially proud of?
Yes. Well, let me rephrase the question, if I may. I'm not sure about a moment, but moments where occasionally I feel particularly happy with what I do. It's at those times, and they happen occasionally, where I feel proceedings may be going off the rails because of something that's happening with respect to one of the parties. In a hearing, it could be because of something that an arbitrator has said or done. And there have been a couple of occasions where I suppose I feel that thanks to what I've learned from others who've come before, I've been able to keep things on track and keep the proceedings moving ahead slowly, because I think that's really one of the most important tasks of an arbitrator, is to ensure that proceedings can run their course, that the parties can have an opportunity to present their case, and of course to end up with an enforceable award.
You practice from Montreal, Canada.
Yes.
And someone once told me that arbitration has Canada, but Canada doesn't have arbitration. This is, of course, not entirely accurate, but at least in ISDS, Canada is not taking the lead from
Yes.
a counsel perspective. Why do you think that?
That's a very good question and very perceptive, if I may say. Um, I don't really know, but I will tell you that I believe that your observation is accurate. I think it has something to do with the fact that in Canada, as elsewhere, rightly or wrongly, and I tend to say wrongly as often as rightly, parties tend to go to the major international law firms. I wouldn't be the first to observe. I think Professor Pellet himself has observed that there seems to be a concentration of cases run, I believe he said, by 30 law firms, or perhaps he even said by 30 lawyers. And that's a phenomenon that we know too well, unfortunately, in Canada also.
I would like to now switch to a different topic and discuss the distinction between common law and civil law in arbitration. And I think you are very well placed to discuss this since you are trained both in common law and in civil law. Do you feel that there is a difference in the manner in which proceedings are conducted by arbiters from different legal cultures?
Certainly. Though, again, this is a rather anodyne answer, but I think it's true nonetheless. Um, Over time, the practice has harmonized to a large degree. We can talk about whether that's a good thing or not, if you'd like, but um, I think the differences in reflexive approaches by common law arbitrators versus civil law arbitrators um, have been greatly reduced over the years, whether it's through application of soft law or whether it's simply the way a community works. People tend to converge on the middle, if you will. So frankly, I see a lot fewer differences or less pronounced difference than I did, say, 20 years ago.
When there are differences, do you feel they are more present in commercial arbitration rather than in investor-state arbitration?
No, not necessarily. Um, uh, I understand why you or one might think that that would be the case. Um, but no, I think in both fields, um, the point I made a moment ago is valid. That is that the practice has tended to converge, again, for better or worse, around a set of best practices, such as they may be, or practices generally that define international arbitration, irrespective of whether it's commercial or a treaty-based arbitration.
Let's touch on some specific points of differences between the two cultures, and one of them is the taking of evidence. And I'm thinking especially of document production, which is very present in common law, not so much present in civil law, but has now become almost a mandatory step in international arbitration. Do you think that this is justified?
First, let me say I see a trend in your questions. We'll see whether the third question on this topic confirms this sense of mine. Um, um, uh, yes, document production has become a common tool. Um, Personally, I don't think that's a bad thing. To the extent it reflects the wish of users over the course of many years. I don't really like to sit in judgment of procedure as it's practiced, as long as the procedure is well practiced and makes sense. Any more than I like to sit in judgment of efforts by states to restrict the discretion of tribunals. As far as I'm concerned, that's for state parties to decide, and procedure is for parties to decide in arbitration. What I do like to control to the extent I can is the way certain procedures are practiced to ensure a degree of efficiency and to ensure that they are in aid of the objective of the arbitration.
And how do you think can we streamline the document production phase for it to be more efficient?
I think there's actually, I don't know if your question is asking for this sort of answer or not, but I happen to believe that there's a lot that arbitrators can do to ensure, perhaps after the fact, but on an ongoing basis, that document production or other procedure is effectively and efficiently deployed. Awards of costs, for example, that look closely at the length and the efficacy of a document production procedure, the number of documents produced by one party to the other, as compared with the number of documents actually relied on, is one way to do it. It's an imperfect tool, obviously. It's also obviously after the fact in an arbitration. But I think early on in a case, there is an opening for tribunals to discuss with parties what their expectations are for a document production process, so as to make clear the understanding that it's not meant to be a classic fishing expedition, a partie de pêche, that this is not necessarily, well, to use a word that people throw around, an Americanized procedure as opposed to a French procedure, but this is meant to be something different than you might be used to in your national courts or I might be used to in my national courts. Now that seems patronizing. Most good counsel know this, but I think there are clear signals that can be given by tribunals early on.
Speaking precisely about the Americanization, Professor Pele recently spoke about the Americanization of arbitration procedure. Do you share this feeling? Do you share that the common law aspect, the common law procedural aspect, have taken the lead over the civil law?
First of all, let me say that I'm aware of his remarks. I actually went looking for a text of his speech but couldn't find it. So I'm aware that he made several points regarding the current practice of investment treaty arbitration during the McNair lectures. I think that's what you're referring to. But I haven't been able to find the text of his speech. Allow me to say that when I started in this field 25 years ago, the Americanization of international arbitration was a hot topic. All right. So I think that perhaps answers the question to some slight degree. I don't know if it means that it is overly Americanized or not, because we've been talking about the same thing for a long time, or it shows that there is a lingering concern, I would guess, by those who haven't grown up in an American system. But do I believe that it is a pressing concern? No, frankly. To the extent I understand it. Again, I haven't seen Professor Pele's remarks, but over the years it's been about things like document production, motions type of practice. And frankly, I see pros and cons to the American litigation system within its own structure, and including its constitutional and judicial structure. Some of those practices, I personally believe, are valuable in aid of resolving disputes and getting to the truth of issues to the extent necessary to resolve disputes. Some degree of document production, I do not find in any way inimical, to the arbitration process. Examination of witnesses, cross-examination of witnesses. Again, perhaps because of the way I grew up in a mixed system, a common law system, but with procedure, which is very much Anglo-American, and I say Anglo-American, not simply common law and not simply American. Perhaps for that reason, I know what I know, and I tend to feel comfortable with the system under which I trained and which formed me. But I honestly believe that certain of these tools are actually useful when correctly deployed. And one thing I'd like to say, again, I may be straying a bit off topic, is I have found that some of the best users of so-called Americanized tools are not Americans. All right, 25 years ago, it may have been the case that German or French or Japanese lawyers practicing international arbitration were learning how to cross-examine. That's not the case anymore. I don't know it. Well, I do know it. Those tools are not taught as early on in lawyers' careers in civilian or particularly continental legal systems. But the lawyers who do well in international arbitrations have truly mastered those tools, whether or not they are American or British or Canadian or grew up learning, the art of cross-examination in second-year law school.
Speaking about cross-examination, I would like to touch upon the question of witnesses. So in the common law system, witnesses are usually presented and then they are orally cross-examined, whereas in civil law, we usually produce a statement of the witness and there is no cross-examination. At what point did you find that the cross-examination of witnesses is useful to you as an arbitrator?
I thought you were going to ask me to what extent do I find a written witness statement, obviously prepared with the aid of counsel, useful to me, but that's not the question. I find cross-examination very important, frankly. Obviously, the better it's done, the more useful it is. But I happen to believe, perhaps it's my own upbringing as a professional, that evidence deserves to be tested. And not only in the mind of the arbitrator or the adjudicator, but that the parties deserve an opportunity to have their own go, their own run, if you will, at a witness, within limits, so as to raise issues that may or may not occur to the decision maker.
And now for our last question, I would like to speak about the issue of precedent. So arbitration does not have precedent, whereas in common law, the precedent is a very predominant in the nature of the legal practice. Do you think that arbitration should have precedent, or what are the pros and cons of having precedent in arbitration?
Very, very important question. First of all, I'm sure, well, I know you know, and I'm sure your listeners know, that while there is no precedent, at least in investment treaty arbitration, there is a certain respect for the authority, if you will, of prior decisions. Though you're right, they do not stand as precedent. There is no doctrine of stare decisis. I think the pros are very simple: predictability, transparency, clarity, and certainty of the law. Not only for users and for the public, but I would say, it would make an arbitrator's life easier too, to be able to apply precedent, if you will. And I know that Professor Pellet had something to say about that during his McNair lecture as well, about the need for greater consistency in arbitration awards. But the cons, I think, are equally obvious. At that point, I suggest to you, you're no longer talking about arbitration. You're talking about a judicial process, and whether one wants a judicial process as opposed to an arbitral process is an open question. But strict application of precedent and stare decisis would be something wholly different than the process in place now. And I say that because judges and arbitrators, in my view, perform similar but not identical functions. The arbitrator is asked to resolve a dispute based on facts and law before her and him. The arbitral process involves the right of parties to name their arbitrators. And the focus is on the dispute. The arbitrator is not, certainly not to the same extent as judges, required or responsible for focusing on broader societal objectives, good objectives, such as clarity of the law, such as development of the law. And again, I say that it seems to me that if one were to impose strict precedent on the arbitral process, it would be a wholly different process than that which users seem at least to appreciate.
I'm wondering whether imposing a precedent, whether strict or not, will ease some of the critiques we hear about ISDS.
I'm sure it would. I'm sure it would ease some significant concerns. Again, I am not certain how that can happen. I'm not saying it can't. I'm saying I'm not certain how that can happen without compromising other elements of ISDS that parties, including states, seem to appreciate as well. Unless one is talking about a fairly restricted body of adjudicators, or a mechanism to appeal decisions, so as to assure, if not in first instance, then at least in a second instance, a corrective function. I said earlier I didn't have the benefit of reading Professor Pellet's speech, but I wonder whether that's not something that he had in mind and that he might have spoken to when he talks about ensuring consistency. It seems to me that ensuring consistency involves a body or a process to ensure consistency, to correct inconsistent / incorrect decisions of first instance.
We will conclude on that note. Thank you very much, Stephen, for joining me today. This brings to an end another episode of Arbitral Voices. Stay tuned for the next episode and see you next time.